Okay. All right. So in the Olympia booth, your name?
Oh, hello.
Yep.
My name is Renee Gomez is my legal name.
I missed that. Ms. Gomez. Okay. It's Renee Rochelle Gomez.
Yes.
Okay.
Also
And
known
so
as
Ms.
Renee
Alt,
Grace. I'm sorry, what?
or no, Ms. Dutch, you've had a chance to talk? Okay. And now I'm being ordered or handed an order to consider under RCW 1077, Ms. Dutch.
Yes, Your Honor. After speaking with Ms. Gomez, I have concerns and I'm requesting a 1077 at this time. I do need to address count 2 and whether there is probable cause given that that particular charge occurred in the city of Tumwater and not the city of Lacey.
I don't know what's happening, but none of that makes sense to me. I didn't talk to anybody. Who are you talking to?
I'm talking to Ms. Dutch. Do you see the attorney with a scarf around her neck?
Yes, but what she was saying doesn't make sense to me. There's nothing.
Okay.
Nothing I had has anything to do with Lacey, and I'm not sure what conversation she's talking about.
City of Olympia. Maybe I misspoke. It's misspoke. It's the city of Olympia. Let me look at that. Ms. Dutch.
Okay, my name is Renee Gomez, and I'm also known as Renee Christ, Jesus Christ Reborn. And the reason I'm saying this is because on February 18th, I'm here to remind the Thurston County Superior Court that on February 18th at 9 a.m., I attended a hearing whereby I declared a state of emergency. A state of emergency due to a complete state of United States government corruption. I called for a legal citizen's arrest of all of the United States court system, the United States government, and I called for the temporary closure of all U.S. courts, beginning from the Supreme Court all the way down to the lower courts. And so this court hearing is actually illegal because there is a citizen's arrest, a legal citizen's arrest that was not taken seriously by the Thurston County Superior Court, but the Department of Justice, the U.S. Department of Justice, is drawing up papers because they realize
Ms.
that
Gomez,
they made a mistake.
Let the judge have a moment to read the paperwork.
The judge can speak for herself. And so what I'm saying is that this court hearing is illegal. And so I'm only participating so far as to let you know that you are actually operating illegally. The Department of Justice knows what's going on. So does the U.S. Supreme Court. So does the U.S. Congress, the U.S. military, the FBI, and the CIA. They all know about me, Renee Christ, Jesus Christ Reborn. There has been a massive persecution against me, and so when I have been trying to report crimes of the government through various hearings that I've been to in the last, several months, in regarding to the illegal abduction and illegal restraining order placed upon me because there was an abduction of my children and trafficking of my children involving the Olympia School District, involving the Olympia Police Department, and so here we are at this hearing having to do with the Olympia Police Department, who are my mass rapists. And I don't want to go into the court case.
This is crazy. We all know that Olympia doesn't exist
Whatsoever. What I'm trying to say is that the Department of Justice is drawing up papers because I have called a citizen's arrest on the entire U.S. government. I have called on February 19th.
So, Ms. Gomez, I'm going to interrupt you for a second, and I just need to hear from Ms. Pinkston from the city of Olympia.
This hearing is illegal, and you know this. Nathan Quartercroft should have called this court closed as of February 19th. And all U.S. attorneys are corrupt because of their affiliation.
I see count number 2 resisting may have occurred in the city of Tumwater when I looked at your police report filed.
Illegal
Something else to know?
Criminal network in the United States government. And so what I'm saying is that all attorneys are practicing illegally right now, including you, a district court judge. District Court County Commissioner.
So,
you are practicing illegally.
I find probable cause for count 1, but not 2. If
you
there's
don't have
more to know, I'd be happy to hear.
This is an illegal an illegal court case right now
So I'm
happening.
gonna, unfortunately, it's pretty clear Ms. Gomez is having a tough time.
No,
And
you
I
need to hear
find
what I'm
that
saying.
there's
This
a
is
good
an illegal
reason
court
for
case.
the
I made
RCW
illegal citizens
1077
arrest via a
evaluation.
legal court
And we're
system.
done with Ms. Gomez. We're gonna have
You're
another
ignoring
hearing
the
in
crimes.
custody
You are
on
literally
May
ignoring the
28th at
crimes.
1:30 for a competency review, and I'm appointing Olympia Public Defense, having found probable cause for count 1, but not count 2.
There was a legal citizen's arrest made on February 19th, 2026 at 9 a.m. In the Thurston County Superior Court. This is a legal
Ms.
citizen's
Gomez,
arrest.
we're
You
done
need
for
to
today. We're
reference
gonna
this,
see you in a few
and you need
days.
to understand that
And
you're
if
operating
you've got an
illegally.
attorney, he'll come
The
talk to
Department
you.
of Justice knows about this, and they're going to tell you about it. You need to contact them. This is wrong, what you're doing. You're ignoring legal issues here. You should not be having a hearing right now, and
So
you know
we're
that.
done with the Olympia booth, and we'll see you in a few days.
Did you hear what I said?
I did.
I want you to understand what I'm saying.
I did.
I made a
I
legal
do
citizen's
understand
arrest
as
via
best
a
I
court of
can.
law.
We're done in Olympia. So in Thurston County, is that
02?
Wait. What's going on here? Bracken. This is Law Talk with Mike. We can't have heart transitions. There are no heart transitions on Law Talk with Mike. There's no cutting of trees, and there's no heart transitions.
Synchrony Bank versus Nicole Waken? Do I have someone here on behalf of Synchrony Bank?
I am Shanae Banks for Ross Term.
Good afternoon, or good morning, Ms. Banks. Do I have someone on behalf of Nicole Waken?
Yes, here.
Good morning, Ms. Laken. Thank you for being here. All right, Ms. Banks, how much is the plaintiff? Now, Ms. Banks, I see that we still had a pending plaintiff's motion for summary judgment, but as we are all here, it may be kind of a moot situation. But why don't you tell me how much is plaintiff seeking?
The total amount is $5,059.87 plus cost of court.
All right, and then are y'all seeking post-judgment rate?
No post-judgment interest.
They wish to waive that. All right, and then is Synchrony the originator of the debt, or did they purchase it?
Synchrony is the originator.
Is this one of those where it was a GE Capital and they switched names? Or was it Synchrony all the way?
Let's see here. I'd have to look and see if that's what happened. And from my understanding, we were here. Did you guys get our motion
This defendant's almost as bad as the last one.
for summary disposition?
We did. That's what I said, Ms. Banks. It is still pending before the court. So if you're giving me your information, it may be that is granted, but Ms. Laken is here, so it's kind of all at once.
Okay, just
All right.
checking because I saw some type of error or something.
No, I'm looking. I mean, but we're here, right? And Ms. Laken has said that she disputes much of it. So since we're here, Synchrony is the originator of the debt. Looks like it was a CARE credit card originally.
Yes.
Okay. I wonder if y'all gave me the last statement. You gave me a whole bunch of them. No. All right. Good morning, Ms. Laken. Thank you for being here. Ms. Banks is representing Synchrony Banks. They're here on behalf of CARE Credit, which is the originator of the debt, and they said there's an outstanding balance still of $5,059.87. So, Ms. Laken, is there an outstanding balance on that credit card?
Your Honor, before we proceed, may I respectfully ask the court to clarify the scope of what today's setting is based on even what you just said about it originally being CARE credit and such. My notice simply stated hearing. I just want to be prepared to address the correct matter. There's 3 matters currently pending. My motion for reconsideration of the denial of the motion to compel arbitration, my answer and counterclaims, and my response and motion to strike plaintiff's discovery.
Ms. Laken, did you pay the counterclaim fee?
I don't know what that is.
You did not. And since you never paid the counterclaim fee, your counterclaim was never filed. So that is denied as a matter of law. Today, we're here wholly about whether
Well, that's one down.
the plaintiff can prove that you owe money outstanding on a credit card debt. That credit card debt was created with Synchrony Bank, who is the petition of the credit. Synchrony, the bank, used a company called CARE Credit. I'm going to show you a copy of the statement. So the plaintiff says you took out a credit card. through Synchrony Bank, and the brand name they used was Care Credit, but you made your payments to Synchrony Bank, which is why you're being sued by Synchrony Bank. And Synchrony Bank provided me 60 pages of affidavits and evidence showing that they sent you all of these bills and you made payment on all of these bills until there came a point where you stopped paying. And their position today is that when you stopped paying, the amount outstanding to you is $5,059.87. And this is the evidence they're showing to support that. Under the Texas Rules of Civil Procedure, the plaintiff need only show me 8 specific things: that they currently own the debt, that the debt is still due and payable, that the debt was opened by the defendant, that the defendant defaulted on the debt, and that there is a right for them to sue. After they do that, they can use documentary evidence. Texas Rules of Civil Procedure say that evidence need not include the original agreement where you originally signed up for the debt. They do not have to show me the very first time you applied for the credit card. The state law says that's not necessary. They need only show me that you did make payments on it, and they've given that by giving me all the statements. They need only show me that there's a balance outstanding, and they can do that with testimony or with pieces of paper. That's what that affidavit is. So Ms. Lakin, the question today is they've met their burden under the law to win their case. In order for them to not get the full amount of the judgment, you would need to present evidence today that you have made payments toward it, or that you are not the Nicole Lakin that's being sued. Perhaps that you can show, and I don't know how that evidence works. I've seen other versions, right? Like, it is not you. You have been a victim of fraud. And then, people have brought in evidence of the fraud. So the question I had is, are you the Nicole Lakin that opened up this credit card with Synchrony Bank for Care Credit? Yes or no?
So let me know if this, so Your Honor, I object to the proceeding to evidence while my motion to compel arbitration remains pending, and I
It's been
preserve my right to
denied. Ms. Lakin,
appeal under
your
section.
motion to compel arbitration was denied, and I'm not giving it a rehearing. If you're unhappy with that, you can appeal, but we are still proceeding with the hearing today. So the motion to compel arbitration was denied. Okay? Your motion for counterclaim had to be denied because you did not pay the counterclaim fee. If you want to appeal, you might still have the opportunity to file a counterclaim, but a counterclaim requires payment of a fee. All lawsuits require payment of a fee.
Your Honor, I do have a finding on this one. I sent you a screenshot because I see a fee was posted from a Samson
Yep,
for the
that's me.
defendant. Well, Udu Sanya Sampson paid a $54 counterclaim fee back in February.
Correct. That's my husband, Samson Odusanya. That's me.
So it looks like it was paid.
What
So
is your
not-
counterclaim for, Ms. Lakin?
That is not what the judge wanted to hear.
Hearsay, lack of foundation, lack of personal knowledge, improper self-authentication, and improper notice under Rule 902.10. And I would love to be heard on that.
Ms. Lakin, what's the cause of action?
Cause of action. Can you help me understand that better?
I can't, because I'm the judge. I can't advise you about, if you filed a counterclaim, you have to say that they have broken the law or committed a crime against you that entitles you to punishment or entitles you to something. What have they done wrong?
Correct. Thank you, Your Honor. So first, improper notice.
But you're here, so that's not true. That's my point. You're here. Clearly you had notice and you filed a counterclaim, so you definitely are aware. So that part is moot. What's
Just
the rest of the claim?
Well, improper notice.
It's not improper. That's what I'm saying. You're here, Ms. Lakin. Clearly you do know. You don't win on a technicality like that. You don't. So move to the next issue.
You waived your notice argument when you filed a counterclaim and showed up.
Okay.
Because they have proven with evidence that you opened up a credit card, someone named Nicole Lakin with your address hasn't paid it. The question I have is it fraud or do you owe some money? And if you owe some money, how much money? Because that's the dispute we can get into, is how much money is owed. But they right now, with their evidence, shown and established that you owe at least $4,000.
So what we have in what we're talking about here as well is SEC filings, and I can get to that. The exhibit, the affidavit, the evidence, what they're sharing it deserves little to no weight for 3 reasons. May I share?
Go ahead.
Okay. So hearsay within hearsay under Rule 805. The attached statements contain transaction entries originally made by third
Ms.
party.
Ms. Lakin, I'm going to stop you right there because I've heard that argument before. That argument is misplaced. It's relying on the Texas rules of evidence, which do not apply in justice court cases for debts. That's why when I started the docket, I highlighted the rule of civil procedure that this falls under. So anything that you're referring to with the rules of evidence is not applicable in justice court because they don't apply. So do you have any other arguments that aren't based on the rules of evidence? Because you're right. If you were in county or district, cool, you've got a claim, but you're not in those courts. You're in a court of no record, justice court. So rules of evidence don't kick in. What other objections did you have?
One moment.
Okay.
Okay. With great respect, Your Honor, Texas Rule of Civil Procedure 500.3E provides that the Texas rules of evidence apply in justice court unless the court formally relaxes them by order.
They do not. You have
Then-
to seek it in advance, and I've not had it sought. They do not apply today, Ms. Lakin.
Okay.
They have to be asked in advance because parties can't just have it sprung on them at the last minute. If
Oh.
you had sought it in advance, I might have granted it, and then we would be all bound by it. But it wasn't, and therefore I can't do it at the last minute. That would be unfair surprise. The same thing would be true if Ms. Banks tried to do that to you. I would say no to her as well. It's about fairness. What's
Okay.
the next one?
Can I respectfully ask the court to apply rules 803.6, 902.10, and 901 as written? If the
No, I
relax-
can't apply the rules of evidence at the last minute, Ms. Lakin.
Okay. No, I understand. Thank you.
Okay.
Got it. Learning a lot.
It goes to fairness, right? It would be wrong to unfairly do that to either side. But if you wanted to do that, call a lawyer and they can explain to you what your options are, like on appeal. Also, if you're in another court, you're going to be in a different set of rules anyway.
Okay.
Go
Then-
to the basics of the claim, Ms. Lakin. Did you open up the credit card? Yes or no? Ms. Lakin?
Yes.
Okay. Did you finish paying off the full debt? Yes or no?
I did not.
Then there's a balance in your name outstanding. How much, to your knowledge, is the balance outstanding?
Repeat that, please.
You said that the balance remains unpaid. To your knowledge, what's the outstanding balance on the credit card?
Patricia,
I don't have any outstanding balance. I don't owe any longer. So for me, I move for a directed verdict, judgment as a matter of law in my favor. The plaintiff has rested without admissible business records affidavit supported by a witness with personal knowledge, without authentication of the cardholder
Yeah, you don't need any of that. You don't need any of that. Okay?
agreement, and without any evidence resolving the chain of title issue raised by plaintiff's own SEC filings. Plaintiff has not met its prima facie burden, and I respectfully ask the court to enter judgment in my favor.
Court overrules. It's going to be a judgment for plaintiff today. $5,059.87 plus cost of court. Judgment is going to enter a 0 for post-judgment rate. Plaintiff is waiving that. Plaintiff established their case sufficiently under the Texas Rules of Civil Procedure. They provided a sworn affidavit. They provided original creditor statements. Defendant admitted that she opened up the credit card, admitted that there was a balance outstanding. The only dispute I heard was about the balance itself. The defendant, you've offered no information to dispute what the plaintiff is otherwise sworn to under an affidavit that fulfills the requirements of the Texas Rules of Civil Procedure for debt cases in justice court. I checked it. Now they've given me all the original creditors as well.
You suck and you lose.
Ms. Lakin, you have 21 days to appeal. We will send you immediate information about your right to do so. If you wish to appeal, but you can't afford the appeal bond, because there's going to be an automatic appeal bond, you may still be eligible to appeal for free if you qualify for an affidavit of inability. And we will send you that information. You have to fill that out and give it back to the court. Okay? Ms. Lakin, can I answer any questions about the appeals process?
No.
All right. Ms. Howard or Ms. Banks, any questions?
No, ma'am, thank you.
All right. All parties are excused. Thank you all. Have a good morning.